in New Mexico, and it's noon on the East Coast. Should we get started? Yes? Okay, great. I am, good morning. It is so great to see all of your faces. I'm Maureen Simmons. I'm Vice President of Philanthropy for PMD Alliance. And we're really so happy that you can join us for the second program in the third part series, How Planning Can Bring Clarity and Positive Change. Just so you know, all 3 sessions will be recorded and available online at pmdalliance.org. If you missed last week's session, it was great. It was with Paul Malady, who is the president of Aging with Dignity. We talked about the 5 wishes. It was a great presentation, so please consider checking that out. Our final session will take place on Monday, July 13th, and it will feature Deborah Curry, who is the Director of Strategic Investment for Yosemite Capital Management, and she's going to talk about really simple ways for leaving a legacy for nonprofits that you care about. So quickly before I turn this over to Anissa, I just want to put out there, when you think of, as we go through these series, and you think of your legacy, what your legacy will be, just to be cognizant of that as you do your planning. Our goal, as you know, and we have so many wonderful familiar faces here, is to provide learning opportunities to connect and collaborate, especially during these extraordinary, you're extraordinary, and we're in extraordinary times. There's simple ways to do that through legacy giving. If you're interested in knowing more, I'll put my name and my email address in the chat, and please feel free to reach out to me. And with that, I will turn it over to Anissa Mitchell, who is our Director of Programs. I know a lot of you know her. In case you don't, she has over 25 years experience as a social worker, working in medical settings, variety of settings. And then beginning 10 years ago, she had a chance to work exclusively with Parkinson's disease, running an outreach center. She runs all of our online support groups here. It feels like she's been here years. She's only been here, I don't know, even, it's just been weeks, literally, and she has done so much. So it's so incredible to have her here. So I'll just turn it over to you, Anissa. Thanks.
Well, thanks, Maureen. Good morning, everybody, or afternoon, depending on where you're from. I am excited about our talk today and our speaker, Kathleen Flammia. I've worked with Kathleen before. We live in the same community in Orlando. And Kathleen has been very important in my work, working with people with Parkinson's and their family members as they try to navigate plans and or what to do in the face of a crisis. So our talk today is actually what you can do to avoid a crisis through advanced care planning. But I want to talk a little bit about Kathleen, because she is just a very experienced and wonderful, caring, compassionate attorney. So she spent nearly 2 decades of her career advocating for elders and family caregivers. She is also accredited with the veterans as a veterans claim attorney. She really uses her skills to advocate for people who are trying to navigate complex maze of decisions making and how to pay for care, such as nursing home, assisted living, or even care at home. How to get your legal documents that you need in order to make these decisions to allow people to do and live where they want, and keeping government and courts out of their lives, which we all would like to do. She has worked as a chair of the Alzheimer's and Dementia Resource Center here locally in Orlando. She's worked firsthand with families struggling with parent-child role reversal, helping parents deal with conflict, or families that are struggling to make decisions. She actually has even hired a social worker to work with her in her practice to kind of have a navigate. And I love that idea and that concept. I would love to see more practices bring on social workers to partner with the attorneys to kind of navigate, you know, not only what documents do you need, but also then what do you do with it? You know, what are the resources and how to access them? So she's a really great resource. And I know that she's got a lot of great information to share with you all today. So I am going to pass this off to Kathleen and welcome you today, Kathleen, to our program.
Thank you, Anissa. Good afternoon, good morning, everyone, and welcome. I have shared my screen. Do I need to do that again, or can you all can you access it?
No, can you please share it again?
Mm-hmm.
Absolutely.
Perfect.
Okay. All right. So this afternoon, I want to talk to you about how to avoid a crisis. A lot of what I do every day is to help families either avoid a crisis by having the proper documents in place that will allow whomever they want to act for them to be able to do so over their finances, over their health care. Unfortunately, when those documents aren't signed and something unexpected happens, like an illness, a fall, surgery, that doesn't leave you as cognitively aware as you were before, and somebody's trying to act for you, if you're not mentally competent to sign these documents, then we have to go what I call the involuntary route, meaning going through a guardianship, or some states call that a conservator process. So let's talk now about how to avoid a crisis.
Hey, Kathleen, just real quick before you go any further, can you potentially put this on slideshow so that we could just see the one slide that you're currently on? We see all of the ones on the left. Do you know what I mean? Like if you go to from current slide up at the top under slideshow, go to slideshow. Yeah, hit that and then go from current slide.
There you go.
Perfect.
I was like,
yeah,
I thought I
thank
did
you.
that.
Awesome. Thank you so much.
Sorry about that.
That's all right.
So when we're talking about avoiding a crisis, you know, in legal terms, we're talking about estate planning. A lot of people think, oh, I don't need estate planning. I have my house, I'm married, my husband or my wife or my spouse can act for me without any documents in place. But that's not true. Once you're the age of 18, you have to make sure that you have some basic estate planning and documents in place so that someone has the legal authority to help you. So when we say estate planning, we're not just saying, well, people that have millions and billions of dollars need it. We're saying you need documents to help you during your life while you're healthy so that if you become incapacitated later on in life, you've given someone the legal authority to make decisions for you over your finances and your health care. And then, of course, part of estate planning encompasses what most people think of when we say the term estate planning, and that is dealing with who gets what of your stuff after you die. So we're going to start by talking about the ancillary documents that are, to me, especially while we're alive, the most important part of estate planning documents. And I am going to share a story with you about a woman who is not much older than me, and she was working, actively working. She was a real estate agent. She was building a new house. So she was living in her house, but she had one under construction. And this is actually a true story. She was bitten by a mosquito, and she got encephalitis, and they put her in a drug-induced coma. She had an adult son. She was divorced. Her ex-husband was actually a lawyer, but she had none of these ancillary documents in place to allow anybody to make decisions for her. So as you can imagine, this woman never dreamt that she would be in this position. None of us do. But she was, and so because of the lack of documents that I'm about to explain in a minute, her son had to go to court to get a guardianship over her. have her declared incompetent by a judge, have more civil rights taken away from her than a convicted felon has taken away from them. And then the son was court supervised over the decisions they made for her person, including her health care, and her property, her business, her building her house, her homestead, paying her bills, that kind of thing. So how could she have avoided that? Very easily by having these ancillary documents in place. So these ancillary documents are necessary for everyone over the age of 18, and that includes if you have some younger children or grandchildren in college, that includes them as well. Because without having these documents in place, once you turn 18, even if you're married, that does not give your spouse the right, nor you as a parent, the right to make these decisions. So what gives someone the power to act for you if you can't? When we say ancillary documents, we're talking about these documents: a durable power of attorney, a healthcare surrogate, some states call that a healthcare proxy, a HIPAA release, which stands for Health Insurance Portability and Accountability Act, and lastly, a living will. And we're going to take them one by one and talk about them. So to me, the durable power of attorney is one of the most important documents that you can have. Now, some states call that the financial power of attorney, but it does need, at least in the document, to say the word durable. And the reason that is so important is because if later on in life you become mentally incapacitated, if the document says that it's durable, it means that the powers you give your agent, the person that you want to help you, sometimes we call them the agent, sometimes we call that person the attorney in fact, but it's the same job, just a different title. But if you have the word durable in the document, then even if later on in life you become mentally incapacitated, the powers you give your agent continue to exist. So that's a very important point to make sure that your power of attorney is a durable power of attorney. It's not just a general power of attorney. So in Florida, at least, the power of attorney, the durable power of attorney, is valid as soon as you sign it. Now, most married couples, unless one part of the couple is mentally incompetent for one reason or another, most married couples give the power to the other spouse to initially act for them. And I'm really big on planning in the alternates. So although you might give the power to each other, we're going to talk about who you should list as an alternate. Now, you want to make sure that you really trust whoever you list as an alternate, because although they're serving in a fiduciary capacity for you, which means if they do something wrong, they can be sued, they are performing their duties without court supervision. So if you come in and tell me that your child has just declared bankruptcy, they're a spendthrift, oh, and by the way, they have a drug and alcohol problem, I'm going to probably talk you out of naming that child as an agent under your power of attorney, because we want to make sure that you can truly trust the person that you're giving the power to. The other thing that's important is that the powers that your agent has are only those listed in the durable power of attorney. So I'm in Florida, and we had a big change in our power of attorney law October 1st of 2011. And on that date, my power of attorney went from 8 pages to about 28 pages. So the reason it's so long is because your agent can only do the powers that you've given them in the power of attorney. And that becomes especially important if we're trying to pay for long-term care by accessing either the VA aid and attendance or Medicaid to help pay for the assisted living or the nursing home. The next document is the living will. The living will is the document that basically says what your end-of-life choices are, meaning whether you want to be kept alive by heroic measures. In Florida, the statute says if you're physically and mentally incapacitated, and that determination is made by the doctor who's treating you and a second consulting physician, and there's no reasonable probability that they will recover from an end-stage condition, a persistent vegetative state, or a terminal condition, and if you mark all three of those on your living will, then the doctors aren't going to do everything possible to keep you alive. They're not going to treat every ailment. Instead, they're going to give you what's called palliative care to manage your pain. My living will goes on to say specifically whether you want them to give you artificial nutrition, which is the feeding tube, or artificial hydration, which is what I think of as the water tube, and also whether you want to be an organ donor. Now, earlier it was mentioned that you had a session last week, I believe, on the 5 wishes. So the 5 wishes is a document that goes into more subjective, personalized detail about what you want done at the end of your life, what music you want played, who you want to be seen, see you in the room, who you don't, all of those kinds of things. So these documents that I'm talking about can go hand in hand with those 5 wishes. The designation of healthcare surrogate, some states call that a healthcare power of attorney, is a document that says if you're not mentally competent to consent to medical treatment, and that basically means, when you go to the doctor, so say you go to the heart doctor and they check your cholesterol and they say, whoa, you have high cholesterol and I'm going to prescribe this statin for you. And you say, okay, and you take the prescription, or it's sent electronically to the pharmacy, and you pick it up and you begin taking that prescription medication. You just consented to medical treatment. But what happens if you're not mentally competent to consent to medical treatment? You don't understand the consequences of taking that statin, or even why the doctor is telling you that you need that particular medication. Then in that instance, the doctor is going to look to your healthcare surrogate or your healthcare power of attorney to make a decision for you. Now, there's a difference between the living will and the healthcare surrogate, because the living will is the document that states what your end-of-life choices are. And your healthcare surrogate, if you're not able to state those end-of-life choices yourself, the healthcare surrogate can't decide what they want to do. They simply become your mouthpiece to carry out your last wishes as you've documented them in your living will. The HIPAA release, the Health Insurance Portability and Accountability Act, I feel pretty confident that most of you know what that is, because it seems to me that every time you go to the doctor, and now even some pharmacies, they have you sign an acknowledgement that you've received a copy of their HIPAA policy. And in essence, what that means is that under the federal law, they can't share any of your medical information with anyone else unless you specifically say who can get that medical information. So if you go to what I think of as your community doctors, your family doctor, maybe your cardiologist, what have you, you may have documents at that specific doctor's office that says, you can talk to my spouse, you can talk to my doctor, etc. But I'm going to give you an example of what happened to my neighbor Joan some years ago. So I knew that Joan's husband was in a rehab facility because he kept falling, and the ambulance would come at least once a week to help him get up. But this particular time, they took him to the hospital. He had a 3-night overnight stay, and then he went to rehab. So she was out walking on a Saturday afternoon, and I had not seen her in months. So I went out to see her and to ask her how she was doing and how her husband Bob was doing. Well, she was walking with a walker, and she had her little dog Maggie on a leash, and it was one of those expandable leashes. And Maggie got excited when she saw me, and she twisted the leash around Joan's walker, and Joan fell and broke her left hip on the sidewalk in front of my house. So I can guarantee you that Joan did not plan to spend her weekend that way, nor did I for that matter, but there There was a nice man that helped me get her off of her hip. We called the ambulance. She was taken to the local hospital. I took her dog in the house. I got her purse. I went to the emergency room. I called her daughter that I never met to say, your mother's in the hospital. Please come get her dog. This is what happened. Well, don't you know Joan broke her hip? So now we've got our husband in rehab, Joan's with a broken hip, and although she's lived next to me for 10 years and she's heard me speak, she has never done these documents. So now her daughter's all worried because her mother had surgery and there's nobody that can access the checking account to pay bills, to pay for the rehab, nothing. So I was able to go that Friday to the rehab center where Joan was discharged, as well to the same place her husband was, and both of them signed powers of attorney, durable powers of attorney, thank God, and healthcare surrogates and HIPAA releases and living wills. So that's a crisis that could have been avoided. And we were lucky that both Joan and Bob were mentally competent to sign these documents. So nobody ever thinks about these documents until they need someone to act for them. And then if they don't have anybody to act for them, it becomes, you guessed it, a crisis. Now, again, if Joan and Bob weren't mentally competent to sign these documents, we would have had to get a guardianship over them. And that's, again, having them declared incompetent by a judge based on 3 examining committee reports, at least in the state of Florida, and then having a court-appointed guardian to carry out their rights and duties, but being court supervised. The next document, the Declaration of PRENEED Guardian, is the document that tells the judge if anybody does go to court and files a petition that says I'm mentally incompetent, I'm telling the court who I want my guardian to be. Now, we have had a minimum of 3 instances in this office where one spouse has died, leaving the surviving spouse living at home. And we've had, and this is 3 different neighborhoods with 3 different nosy neighbors who have come in and said, oh, the surviving spouse is my friend, and they're not mentally competent to act for themselves, especially now that their spouse is gone. And I want to be their court-appointed guardian, and I want to be in control of their finances and their health care decisions. Well, you can imagine that if there's children of that surviving spouse, or even stepchildren, as the case may be, those people would want to step up and act for their loved one rather than some neighbor that isn't related at all. So again, this Declaration of PRENEED Guardian document is the document that says if anybody goes to court and files a petition saying I'm not mentally competent, this is the person that I want the court to know I want to have in charge of me under a guardianship. We're going to just talk about probate for a quick minute because we're next going to talk about trust. So probate is basically the process of after you die, if you leave things in just your name without a joint owner or a beneficiary, because let's face it, our retirement accounts are just in our name, but you can easily fill out a designation of beneficiary form with your IRA, your 401k, 403b, what have you, custodian, and then that IRA or retirement asset is going to go directly to the named beneficiary and avoid probate. But if you pass and you leave something in your name and your name alone, so there's no joint owner or no beneficiary, then in order to get it out of your name, it's going to go through the probate process. It's first going to be available to pay any creditors that you have before it goes to your beneficiaries, either those listed in your will or those listed by your state intestacy statute, meaning if you die without a will, who your state says inherits from you. So part of the basic estate planning package, in addition to those ancillary documents, is having a last will and testament, which basically tells the court who should inherit from you and who you want your personal representative to be. Now in Florida, that term personal representative means the person that you appoint, again in a fiduciary position, to hire the lawyer and administer your will through probate. I'm originally from New Jersey, and up north, we call that person the executor. So you may be in a state where the personal representative is called the executor, but again, it's just a different word for the same job. Now, if you have a will, it's a matter of public record. which means once it's filed with the court, anybody can go down and read it. So if you had, say, 3 children, and you identified the 3 children in your will, but you said, for reasons best known to you, or reasons best known to that child, you specifically disinherited them, that child could go down and read that will and then file something in that probate proceeding saying that you weren't mentally competent or you were under duress, you would never have cut them out of your will, and they could try to challenge that will. That's why I say that it's easy to contest, because in probate you have a judge who's presiding over that file. Now, let me say that with married couples, typically there is no probate on the death of the first spouse. That's because most couples have things jointly titled, like their real estate, their bank account. If they have a life insurance policy, they've made sure to list the surviving spouse as the beneficiary, and the same with retirement accounts. That's why I say for most couples, there's no probate on the death of the first spouse. Let's compare having a will with having a trust. So a trust is basically an agreement that you, or a contract that you make with yourself. And it's a private document even after you die. So if you die leaving a trust, a copy of the trust doesn't get recorded with the clerk of the court in the county where you died like a will does. Instead, your successor trustee would file a one-page called a notice of trust that says your name, the date that you died, and the name of your trust. And your successor trustee would sign their name, print it, and put their address. That's because if you die leaving a trust, any assets in that trust are available to pay any creditors that you have for up to 2 years after your death. So that tells creditors that they can go open a probate if there isn't a need for one to try to collect money out of your trust to be paid. I think I've seen a creditor do that twice in my 31 years of practicing law. But when you have a trust, you design the trust to say what happens to your assets while you're alive and what happens to them after your death. And there's different kinds of trusts. There's not just a one-size-fits-all. So let's talk about that. Most people have a revocable living trust. Sometimes it's just called a living trust, which is obviously one that's created while you're alive, and it's funded while you're alive. Let me take a minute and explain what that word funded means. So if you sign a trust, but you don't go through the extra steps of retitling, say, your bank accounts or your non-retirement brokerage account in the name of you as trustee of your trust, then you have what we call an empty or a dry trust. And in order for assets to get into it, if you don't fund it while you're alive, after you die, those assets are going to go through a probate and then be given to the acting trustee of your trust to be distributed the way your trust says. So it's really important that after you sign your trust, you make sure that you take the extra steps needed to fund the trust, meaning retitle the assets in the name of the trust. Now, for a revocable trust, it can obviously be revoked, amended, or terminated at any time. It's flexible, which means if you want to make changes to it, you absolutely can. And we do that by just doing an amendment to the sections of your trust that you want to make a change to. If it's properly funded, then the assets avoid probate, which is a great thing. And it also prepares for if you're alive and disabled, which none of us ever think is going to happen to us. But if you are, it avoids the guardianship because you've named your successor trustee to step in and manage the assets of that trust. If you have a large amount of money, then we can do federal estate tax savings, currently $11.58 million, meaning any one person can die, leaving $11.58 million without their estate paying a federal estate tax. Now, you may be in some states where they have a state estate tax as well. We don't have that here in Florida. But if you have a large amount of money, you probably are going to want to talk to an elder law or an estate planning attorney about creating a trust to take advantage of doing some federal estate tax savings, if not state estate tax savings. One of the other trusts that we use is an irrevocable asset protection trust. So As an elder law attorney, I do probably 98% crisis planning for Medicaid, meaning an unfortunate incident happens, somebody gets diagnosed with an illness, which requires them to go from living in the home to perhaps going to the nursing home. And when they find out that that bill's $8,500 to $10,000 a month, they're not sure how they're going to pay for it. But if you're recently diagnosed with something that you think is going to cause you a lot more health problems in the future, and if you don't have long-term care insurance, either because you couldn't afford it or now with your diagnosis, it's highly unlikely that you would medically qualify for it, then you might want to think about doing some pre-planning. And that's where we use these irrevocable asset protection trusts. So the key is that if you place some fund assets into this irrevocable trust, after 5 years of putting the last asset into it, those assets in that trust are not available assets for Medicaid purposes. After 3 years, they're unavailable assets for VA purposes. So the irrevocable trust can be designed in different ways, but the main point that you have to understand is that although it's your money and you may be the person creating that trust, once you put the assets in that trust, you have to give up what the Internal Revenue Code calls, or the IRS calls, all dominion and control. So that means you're not the trustee. You can't be in charge of administering the trust. On one kind of trust, you can get the income from the trust. On another kind of trust, the income would go to the lifetime beneficiaries, which is typically your kids. So let me give you an example. Say my mom has a homestead worth $200,000 and a non-retirement savings account worth $100,000. Well, if we want to use an irrevocable trust for her, we have to make sure that when we put that last asset into it, that starts the 5-year clock ticking for Medicaid and 3 years for the VA aid and attendance. So if we transfer her homestead into the trust, if she sells it, she's not going to have the proceeds of the homestead to deal with because it's going to go into the irrevocable trust. And it's not going to mess up the start of that 5-year or 3-year look-back clock ticking. After the 5 years or the 3 years, the $100,000 that was put in that trust is an unavailable asset for either VA purposes or Medicaid purposes. So again, you have to pick who the lifetime beneficiaries are. Most of the time, they're your kids. And then, of course, you would design who inherits that from you after your death. The reason that this works in Florida is that we typically have the children on board with us. So if we put the assets in the trust, the children have the legal authority to take the assets out for their health, education, maintenance, and support, or for any reason, depending on our choice of trustee. So if the children can get the assets out of the trust and put it in their name, because it can't come out of the trust and go back to you in any way, shape, or form, the children would get the assets out of the trust, put it in their name, and then if you had a bill that you needed to have paid, that bill could get paid directly. So we recommend that when we're doing pre-crisis planning, especially when someone's been diagnosed with something that they know may likely cause additional health concerns in the future. A special needs trust. So when we're doing especially crisis Medicaid planning for a married couple, I always ask what kind of estate planning do they already have. And if they have any at all, 95% of the time they have what I call a sweetheart will, meaning husband's will says, wife, I leave everything to you. And wife's will says, husband, I leave everything to you. Well, if I'm trying to get the husband or the wife qualified for Medicaid to help pay for a nursing home, I don't want to leave that will as it is, because if the well spouse dies first, I am going to be leaving to the ill spouse all of the assets that were in the well spouse's name. So that means the ill spouse would then have over $2,000 of assets. So that would not be a good thing. They would be disqualified for Medicaid. So we tell the well spouse, you don't have to disinherit your husband. We just have to create a special needs trust in Florida that has to be done in the spouse's will, so that we can leave assets to the ill spouse without disqualifying them from Medicaid. And the same can be said if you have an adult disabled child. We don't have to disinherit that child. We would just leave assets in a protected special needs trust if that child is on SSI, supplemental Social Security, or on Medicaid. Heritage trust, this is one of my favorites. So when we're doing estate planning, I'm basically doing a lot of questioning and listening about you and your family and your kids, even though they're adults, and to whom they may be married, and your grandchildren, because I always ask this question and I always get an answer right away, and that is, do you have adult children? Yes. Are they married? Yes. And would you consider your son-in-law or your daughter-in-law to be an in-law or an outlaw? And typically the client starts laughing, but immediately gives me an answer of either, oh, they're an in-law, I'm closer to them than my son, you know, they're wonderful, or, oh, an outlaw, definitely an outlaw. And I say, okay, well, if we leave assets outright to your child as part of your estate plan, then if they're married and they add that money to a joint bank account with their spouse, if that spouse sues them for divorce, then you're basically looking at having half your inheritance walking out the door. And that's when we talk about a heritage trust. So it can protect your inheritance to your children from either outlaws, if you have those instead of in-laws, or the beneficiaries themselves, if they're spendthrifts or have a drug or alcohol problem, or if they have a lot of creditors. So it just depends really on our choice of trustee. That would dictate the kind of distributions that have to come out of the trust, and how we would design the trust. So there are ways to protect the inheritance that you leave children as well. I think that's the end of my, how am I doing on time? Because I'm just talking and talking. 12:38, okay. So I think that's the end of my presentation. For Florida, I do have on my website on the bottom of the homepage a family guide to paying for long-term care, if that will help you finding out basic information about VA and Florida Medicaid qualifications. So I guess at this time, I would like to open it up to any questions, whether it's by chat or live. I'm okay either way.
Awesome. Thank you, Kathleen. Actually, we do have a couple of questions that came through the chat, and then we'll open them up to anybody who wants to just speak up and ask a question. So our first question is from Hetty, and I think you may have covered this, but just for clarification purposes, can one's IRA be included in the revocable trust to prevent probate?
No, and you don't want it to be for tax reasons. So the IRA, because, you know, we're working, we're saving money, or we've saved money in our retirement account, only when you take money out do you pay income tax on it. So we would never retitle that in the name of a revocable trust, because it would require all the income tax to be paid at once. I would strongly suggest that you name a beneficiary on it, especially if they're over the age of 18. Now, we did have a change January 1st of 2020 to the retirement accounts and how you can leave your retirement account to a beneficiary. So a spouse can still roll it over, but a child can no longer stretch it out to take the required mandatory distribution over their lifetime. And that's a change that is from the Secure Act. So that's a little bit too much to go into today, but I would definitely say talk to your financial planner or your estate planning attorney about the designation beneficiaries on your retirement accounts. But to answer your question, Anissa, no, we would never title that in the name of the trust.
Okay. Larry wanted to know from Palm Desert, what's the pros and cons between an elder law attorney and an estate planning attorney?
That's a great question, Larry. An estate planning attorney basically is one that does estate planning documents, but an elder law attorney prepares those documents with a different twist in mind. So we do consider tax consequences, obviously, but we ensure that you have the proper language, especially in that durable power of attorney, to assist or allow your agent to do public benefit planning, meaning Medicaid planning or VA planning. most estate planning attorneys, durable powers of attorney that I've seen, do not have that at all. And they also take into consideration if one spouse dies and they're disabled or don't have long-term care insurance and they have an illness, counseling on the use of a special needs trust. So those are two areas where estate planning attorneys don't do that the way that elder law attorneys do.
That's excellent.
I see
All
your
right,
thumbs up.
Jean had a question. She's been chatting with me, but Jean, I think it would be clearer if you're willing to ask directly, if you're comfortable with that. All right, you can unmute yourself and just ask Kathleen.
Okay, for several, can you hear me?
Yep.
Yes,
Okay.
ma'am.
I'm 83, I'm 82. 4 years ago, I was hospitalized for 3 days. My husband was fine, he could take care of everything. That is not the case now. And I have been trying to formulate a plan B, that what happens to him if I am suddenly temporarily or permanently gone. I was trying to find various respite options, and we do have long-term care insurance. We have in-home help right now with that. And when I talked to my long-term care the other day, they said, well, no, you can't make any kind of arrangements or anything until the need is immediate. Which of course, if you find a place that he would have respite care, they have to go through the paperwork. And while he is sort of in limbo, but I don't know, if you have any kind of options. I did contact the long-term care agency, and they said, well, yes, we can take care of it. Of course, it would be self-pay for us beyond the daily limits that the insurance has. But is there any way that you can suggest to, it's been on my mind for years, just what happens to him if I'm suddenly not there? We have all the documents in place we have for many years, the trust and things like that. So this is sort of a hands-on question.
Okay, Jean. So is your concern if something happens unexpected to you, getting care for your husband going through the long-term care policy, or it doesn't matter if you're going through the policy?
Oh yes, we have to use. It's very expensive, and if for any, I mean, it's prohibitive as far as 24 hours a day for any length of time. So I would. Do you have any suggestions for me? Because the immediate need is there. Boom, you fall, you have a stroke, or whatever it is. He's home, maybe in the middle of the night or whatever, and they take me to the hospital. What happens to him? What is your experience with that?
So I have two thoughts. My first thought is, did your husband sign a power of attorney?
Yes, we have all the appropriate. If I'm not available, then it goes to our daughter and then our sons. So yes, we have our ducks in a row.
So your daughter needs to know where the long-term paperwork is so she can file a claim and be on standby, so to speak, if something happens to you.
We already have we have the claim with the long-term care because we're using in-home help.
So what I was going to say is your daughter needs to be on board if something unexpected happens to you, to step in your shoes and arrange for that care and fill out the paperwork for the respite care. Now, when you say respite care, do you mean sending him to a facility on respite care?
Yes.
Or, because you said two different things, 24/7 care or the facility?
No, I would want him to go to a facility to know that all his needs are taken care of. None of our children are in the area. We're in Phoenix, our daughter's in Atlanta, our son's up in South Dakota and Nebraska. So having her, especially with this virus, she couldn't jump on a plane and be here. So that's added a little extra urgency to this idea.
Do you know what a geriatric care manager is?
No.
A geriatric care manager is like kind of a social worker. Okay, I'm a woman, so I can make this sexist comment. It's like a paid daughter, okay? So they take care of things for you. They get to know you, have a relationship with you, know your daughter, know the long-term care paperwork. And this is somebody that if you're going to the hospital and if you can't talk, your daughter calls and says, get over to the house, take care of my dad, call the home health company, or, you know, to have somebody come and stay right now, or call the facility, you know, the next day and fill out the paperwork. The other thing I'm thinking is, do you know if you have a reimbursement or an indemnification long-term care policy? Because if you have a reimbursement, you could pay for the long-term care, file the claim, and then get reimbursed.
No, the long-term care will cover a certain amount per day. So whatever the hourly rate is of the person that is taking care of my husband, when that limit is reached, it would be a self-pay. So I don't know what you mean. We've passed all the 90 days and everything. We've had the long-term care for a year. So we are established with a company, and they said, yes, we can take care of that. Again, I'm just starting the process of going through the company instead of trying to do this. So how do I find a geriatric care manager?
You can Google geriatric care. I'm blanking on the name of the association. There's a national association.
Yeah, it's now called Aging Life Care. I want to say it's Aging Life Care Association. We'll look it up and put it up in the chat.
Okay. Fine. That sounds exactly like something I need, because I want to have everything in place. I don't want to depend on somebody else. I don't like the unknown, and I don't want him stranded at home, vulnerable and things like that. So I think I'll just let you go back to the rest of this group and see what happens. The Aging Life Care Association, is that what you said?
Yeah, I just put the link to their website on there, and you can search by your location.
Thank you.
So they changed the verbiage. It used to be called geriatric care managers, and then they changed it to aging life care managers. It's the same thing, it's just different verbiage.
Euphemism.
Yes.
Okay, thank you.
Thank you. Love to ask if anybody else has any questions for Kathleen. Feel free to speak up. I knew we threw a lot of information at you, and she did reference Florida, but you know, every state has a version of the same thing, so feel free to ask any questions that you might have.
Rachel.
Rachel? Oh wait, you're muted, darling. Can't unmute yourself. There you go.
There you go, Rachel.
Okay, hi.
Hi.
I have a question about some of the account transfers that need to happen. I'm an adult child. My dad has PD, and calling like the cable company, calling the pest control company, they're all under his name. He no longer has a voice to speak, to give authorization to myself or to my mother. So how do we go about reaching out to these companies to have basically like a power of attorney or authorization given to myself because he can't speak?
Does your dad have a power of attorney?
Yes.
You would
It's
send the
my
companies
mother.
that power ahead of time.
So you'd have to let these places know that she's the power of attorney.
Give them a copy.
Okay. Thank you.
You're welcome.
And that's a really good point, because I don't think that we even think in terms of basic day-to-day life management of calling the power company if you're having an issue, or your cable company. I know I've experienced that personally, where we had an issue with an outage and I called and they wouldn't talk to me because my husband was listed as the primary person on there, and he was unavailable at the time. And so like those kind of things, if you have the power of attorney, can help address that, but you don't even think in terms of that. We think of long-term planning, you know, in those kind of crises that Kathleen's explained, but even those day-to-day issues can be a part of it and adds to stress. Ken asked, does Oregon have a pre-need guardian document? Any special info for Oregon?
I don't know, but let me direct you to another resource. It's called Elder Law Answers, and you can put in your state and search specifically for information on estate planning. I think they have a question and answer board, Medicaid information, and that state is specific if you put in your state. Elder Law Answers.
That's awesome. And Trang just put that up on the web or on the chat for you guys. You can link directly from there. Bill asked the question, is it hard or impossible to get long-term care insurance after being diagnosed with Parkinson's?
I don't know. I don't know.
And that's more of an insurance, I think, issue than it is a legal issue. All right, any other questions for Kathleen? Can't see everybody, so if you do, either chat it or just speak up. We're happy to just have you unmute yourself and speak up. All right. Speak now or forever hold your peace. Okay. Well, if we don't have any additional questions for Kathleen, oh wait. One person, Jean said, I really doubt that anyone can get long-term care with Parkinson's. I'm not going to speak without a surety. I have heard that once you have a diagnosis such as that you may not be able to get it. But I am not an expert in that, and so I can't be assured. So I would speak to someone who actually deals in long-term care policies to see what your options are. There may be some of, maybe if it's not that policy directly, maybe there's some options available. All right, well, if there aren't any other questions.
Oh, sorry, I said there was another one.
Oh,
in the chat
okay.
right above.
I saw one from Sonia. I'm a daughter of an elderly parent. What are the steps to take upon death? You know, you can't really do a lot of anything until you get the death certificate, which generally takes about 10 to 14 days. But you're hopefully are going to go over what they have before they pass. So you know if there's beneficiary designation forms that you have to get, claim forms, kind of a thing. The funeral home basically notifies vital statistics and Social Security, that kind of thing. So really what you're waiting on is the death certificate in order to take steps to move forward.
Awesome, awesome. So this has been fantastic information, Kathleen. I really appreciate you taking the time and sharing your expertise with us. I do want to remind everyone that we do have some great live streams coming up this week in our holistic programs. We have the Frontiers of Neuroprotection on July 10th. We have our support group this afternoon. So if you've not joined that for anybody with Parkinson's, and then I want to pass this back off to Maureen, and she's going to close us up for the day.
Thanks, Anissa, and thank you all for joining us today. We really appreciate that you were able to share this, and thank Kathleen so much for all of the really great information you shared. I also wanted to remind everyone about the last session in the series, the Legacy series. It'll take place again on Monday, July 13th, titled Composing a Legacy, Exploring Charitable Giving Options. I think a lot of what Kathleen talked about today will really dovetail nicely with all the information that Deborah Curry will share with you. So hope you can join us, and hope to see your wonderful faces then. And thanks again for coming today.
Bye.
Bye. And yes, this is recorded for anyone who wants to go back and share it. It will be posted later this afternoon. Thank you very much for joining us.
Thank you.